session.
Thank you. Be seated. Got a lot to get settled here. Now is the time for oral argument in cause number 1CACV19-0240FC. Excuse me. Kelly McQuillen, is that right? Versus Kyle Hufford. For everybody's information, the proceedings, this probably won't come as a shock to you, are being both video recorded today and live streamed. So if technology works as it's supposed to, you can critique yourself in a couple of weeks using those format, those whatever they are. Council, each side will be entitled to 20 minutes, and we would ask that you respect the time period. The timer located on the podium will let you know how much time you have left, and for the appellant's benefit, if you wish to reserve any portion of your 20 minutes for rebuttal, please let us know so we can try and avoid taking up all your time. However, ultimately, your reserving of rebuttal time will be on you. We've reviewed the briefs and conferenced this case this morning, so we are well aware of the facts and issues attendant to the argument. We tell you that so you can figure out how you want to use your time. Counsel, when you come to the podium, I would ask that you state your name so we all get off on the right foot and who you represent. And with that, Counsel for Appellant, you can begin.
Good morning, Your Honors. May it please the Court. My name is Erica Gadberry, and I represent Kelly McQuillen. Your Honors, this is a pretty simple issue before the Court. The issue is, does 25-814C apply when the trial court is presented with two competing presumptions of paternity? This case deals with a presumption of paternity that is a voluntary acknowledgement of paternity pursuant to 25-812. And a presumption of paternity that is a DNA test. In this case, the court, or 25-812 is a contract between two people, mother and father. The mother and father can sign the voluntary acknowledgement of paternity. They are then presumed to be the legal parents. Well, in this case, it would be father would be presumed to be the legal parent. The 25-812 provides safeguards so that one party cannot unilaterally dismiss, it would be the father in this case, from being a legal parent without another person able to come in and take on that role. When there are cases where there is one father, one mother, and a voluntary acknowledgement of paternity, the requirements that or the safeguards that are put in place pursuant to the statute are still in place. When you have a third party that comes in, then 25-814 is invoked. And in that case, we have 25-814C that says when you have two or more presumptions, which we have here, the voluntary acknowledgement of paternity and the DNA test, then the court is required, pursuant to 25-814C, to essentially invoke a balancing test. And specifically it says, any presumption under this section shall be rebutted by clear and convincing evidence. If two or more presumptions apply, the presumption that the court determines on the facts is based on the weightier consideration of policy and logic will control.
What
So
does
Stereo.
I will defer to Judge Johnson.
As I understand the argument, it is that even when you have a voluntary acknowledgement that's been filed with the court, it is just a presumption for purposes of 814, and the court needs to weigh it. But how do you square that argument with the last sentence in 814C, which is a court decree establishing paternity of a child by another man rebuts the presumption, doesn't the filing of a voluntary acknowledgement under 812 result in a decree which would have,
If that was the case, then this court's determination in Drummond would be incorrect, because in Drummond, the court essentially said that because a third party came in, essentially providing the court with a second presumption, it was a DNA test, that alone, and let me find the quote here, so in the paragraphs 8 and 9, at the end of paragraph 9, it's stating that because there are two, and I apologize, I can't find it here, but it essentially says that when you have two presumptions of paternity, that is enough to create the balancing test that has to happen. And so when that happens, and I wish I could find the quote, and I apologize for not having it right in front of me here.
I think it's a paragraph 21, maybe 10 or 21. Yeah, based on weightier considerations of policy and logic.
Correct. And so in that case, and I'll just look at the case here, but it acknowledges that argument and says that it's still just a presumption. So when you have the presumption, the court is required to do the balance.
So your argument is that because Brumman ignored part of the statute, we should ignore part of the statute as well?
Well, you're not ignoring part of
No,
the
we
statute.
are, because the statute says that, or you're asking us to, because the statute says that it is a judgment. And then there's 812H, which says, in this case, you have 60 days to challenge a voluntary acknowledgement of paternity. We'd have to ignore that provision as well, wouldn't we?
If the court and the statute essentially did not want you to be able to bring in a second presumption to challenge, not even challenge, but present the court with a second presumption, it wouldn't have 25.814.4. That specifically says that you have a voluntary acknowledgement of paternity that can be weighed against the other presumptions. If 25.812 was not to be included in 25.814, the statute would have said that. In addition, they wouldn't have included it in 25.814. So you have...
So there's no finality ever?
Not when you have a second presumption of paternity.
So for all time, we can come back, so we ignore the 60-day period to challenge these things, because anytime someone presents another presumption, you can then reopen the whole can of presumptions.
Correct, and that's what 25.8...
I don't know if there is such a thing as a can of presumptions, but I started down that way.
But that's correct. That's what 25.814 is designed to do.
Then what does 25.812H, I think it is, do? What does that 60-day mean, if it doesn't mean that there's some finality after that 60-day period closes?
The 60 days is specifically if one party is challenging the voluntary acknowledgement of paternity. So if you have one husband...
Right, and after that 60-day period, it's now a judgment, and that's final. So
It's a
unless you have an
final judgment,
85C
but it's
basis to...
Go ahead, sorry.
No, unless you have an 85C basis to overturn that judgment, you've got a final judgment, don't you?
You have a presumption, and all of the cases that...
Wait, I'm sorry. I think the question was, after the 60 days following the filing of the
Acknowledgement.
yeah, that has to be set aside. It's not just a presumption. It's the law, effectively.
And I disagree that it's not a presumption. It's a final judgment as to the presumption of paternity. And all of the cases that we've cited essentially call it a presumption of paternity. If you look in Andrew R., it essentially says 25.814 or 812 is a presumption until established otherwise. And it even cites 25.814C to say that it can be set aside through other means.
Well, it can be set aside, meaning it's a judgment that needs to be set aside so that it gets back into the lower category of a presumption. Isn't that a logical way of interpreting the two statutes?
See, and I disagree with that based on the language of Andrew R. Andrew R., it says, once signed, a purported voluntary acknowledgement of paternity is presumed valid and binding until proven otherwise. It then cites 25.814A4, stating that providing that a man is presumed to be a father of a child if a notarized or witness statement is signed by both parents acknowledging paternity. It also cites 25.814C stating that a presumption under 25.814 shall be rebutted by clear and convincing evidence.
In the Andrew case, was the voluntary acknowledgement filed with the court? See, doesn't that turn it, after 60 days, into a judgment?
It's a final presumption, and I don't think that it goes beyond the status of a presumption. Again, if it was meant to be final, you can't do anything with it, then it would have said that 25.814 doesn't apply, or 25.814 would not have included it as a presumption.
So, I'm sorry. Go.
Well, I'm just going to make the point that you can have a voluntary acknowledgement that's not filed with the court. It's just sitting out there in someone's desk, and it's a presumption under 814. But 814C, the last sentence, seems to say to me that once you file that with the court and the 60 days run, then it's a judgment, and it no longer is a mere presumption unless it's set aside.
But under that analysis, then nobody could come in and challenge a voluntary acknowledgement of paternity.
After the 60 days.
After it's been
60 days.
filed with the court and become an order.
Correct. So if you have a biological father who wants to come in and says, I'm the biological father, I want to establish paternity, and there's a voluntary acknowledgement of paternity that's been put in place, under that interpretation, the biological father cannot come in and challenge and provide a second presumption of paternity.
That's
But
the
he-
pickle, isn't it?
But couldn't he then, under 85C, move to set aside that judgment by showing fraud, duress, or material mistake of fact?
That is correct.
So
But
there is
mother
a
can
vehicle for it.
But mother essentially can do the same thing.
Right, and so I'm not, don't speak for the entire court. I think your client needs to have prevailed on the 85C grounds and show us that there's fraud, mistake, or material mistake of fact, because I can't, despite Drummond, read 812D where it says, acknowledgement of paternity made pursuant to this section is a determination of paternity and has the same force and effect as the Superior Court judgment. I can't ignore that. So tell me how your client can win under 85C.
Pursuant to fraud.
Yeah.
So we made the argument that there's fraud upon the court. With regard to fraud upon the court, the court was clear, number one, that a voluntary acknowledgement of paternity in Alvarado can't be used as a way around the adoption law. In addition, when you have fraud upon the court essentially has to get rid of the voluntary acknowledgement of paternity. There's not a lot of case law in Arizona that deal with this, so we went outside into another jurisdiction. In McGee v. Gagno, it especially talks about fraud upon the court and how it's inappropriate to use a voluntary acknowledgement of paternity that isn't supported by the facts. In this case, in the voluntary acknowledgement of paternity, we have somebody who's absolutely not the father of this child. And so it's a fraudulent document.
So is it any time a person knowingly and voluntarily signs a VAP knowing he's not the father, that's a fraud on the court?
Absolutely.
Where's the law for that?
The law...
Let me rephrase the question if I could. Is there any case you can show us that where the person who committed the fraud can have a judgment set aside on the fraud on the court doctrine?
That takes away, essentially, the fraud is on the child. The child is entitled to be supported by his biological father.
So that we should send it back to the trial court to appoint a guardian ad litem and see what the child wants done in this case?
No, the court needs to...
But right now, our case is your client committed a fraud on the court, or you're arguing that she defrauded the court, and therefore she wants relief from the judgment.
From her conduct.
Based on her conduct.
But the most important thing to look at here is that it's the child The child here is the one that suffers. The child has an incorrect birth certificate. The child isn't supported by his biological father. In fact, the child's on state aid because legal father is nowhere to be found, doesn't want anything to do with him. We have the affidavit saying, I don't want anything to do with this child. So now we have the opportunity, we have DNA testing that establishes that we know who the biological father is, and pursuant to 25814C, the court has to do a balancing test to determine which of these presumptions is the most appropriate presumption.
But the court does, the child does have permanency, right? And isn't that what these statutes were intended to do as well? Provide the child with permanency, where someone comes in and does a voluntary acknowledgement, says, I'm the guy. Then that becomes the law, and the child has permanency in that, correct?
That argument essentially means that nobody else can come in and claim paternity.
Precisely. And
But
that's what the
that's-
60 days is about, right?
But that's not what the law says. The law says, and all of the case law says, if another person comes in and provides a competing presumption of paternity, then the court weighs that. And so this hardline rule means that if you have a biological father that comes in and you have competing presumptions, there's nothing that can be done. And that's not what the case law supports.
What is going back real briefly to the fraud on the court argument, what in the record supports the facts that would support a fraud on the court claim?
The record supports that there's a fraud upon the court because both parties acknowledge that the man that's listed on the voluntary acknowledgement of paternity is not actually the father.
But is there something in the record that suggests that it was a fraud? In other words, that he knew he was not the father at the time that he signed the...
Yes, absolutely, and I can point you to that. We've got the transcripts from the court hearing where both parties, the legal father signed an affidavit essentially stating that he was not the legal father, and in the transcripts, it was stated that...
By whom?
By mother's attorney.
Okay, so we're talking about evidence, not statements of attorneys. Is there any evidence in the record
There
to
was
support the
no
notion?
evidentiary hearings in this case.
But
Okay.
does his affidavit, which I've read, does not say that he does not acknowledge, and neither does mother actually, as I read it, saying we knowingly committed a fraud on the court when we filed these.
Mother's statement now that she knew that legal father was not the father, and
But in her affidavit, I think she said something along the lines of, we knew there was a chance, or we knew it was possible, I think, right?
but if you sign a voluntary acknowledgement of paternity, essentially stating that father is the father, and there's a chance that father is not the father, how is that not a fraud upon the court? Because you're stating to the court, this person is the guy, this person is the father, and if you have a question in your mind, then that's not the appropriate avenue to take. You need to get a DNA test, and then if that person is not the father, you need to adopt. You can't just sign a voluntary acknowledgement of paternity and say, we want to have a happy family, so we're going to sign a voluntary acknowledgement of paternity. That's not an appropriate avenue.
It seems to me that the strongest pitch for your position is the paragraph 16 in Drummond, where it says if 812E applied in that case, we would create the anomalous situation where a child's biological father can challenge the paternity of a child born in wedlock at any time, but has only 60 days to do so for a child born out of wedlock. That is incongruous. I'll grant you that. But Drummond was a different case. Drummond was a father wanting to acknowledge paternity, and we can't ignore that.
But there's nothing in the statute that differentiates between a father that wants to step up and support his child and a father that doesn't.
But, there is in this case, because mother knew who the father was, and mother, she's stuck with the 60 days, isn't she?
Unless she brings in a second presumption of paternity, which has happened here.
So the 60 days is just kind of anomalous. It's just kind of out there, but it doesn't really mean anything, even though the law says that this becomes equivalent of a judgment.
it means something in the fact that she can't then go to legal father and say, without a third person, 3 people to 25-814, she can't go in and say, I'm sorry, you're not the legal father. I'm going to have you tested to establish that you are not the father, because that doesn't invoke 25-814C. There's not that second presumption. You have to have the second presumption. No second presumption than 25-814 with the 60 days is in place.
Did you want to save some time for
I
a
would,
while?
yes, thank you.
Good morning, Your Honors. May it please the Court. Rob Singer, representing the appellee, Kyle Hufford. Sitting at the table with me is Joanne Falgett. She's the Assistant Attorney General. She's told me that I could use all the time, but I may cede a couple minutes to her to tell you a few things about what the state believes on this issue.
I would like to hear what the state position is.
Absolutely. Then I'll move a little quicker. So
Did you file a brief? Did the state file a brief? Okay, thank you.
Help us out with judgments that aren't judgments, would you?
I can't, Your Honor, because I think there's two statutes in here. One is a statute that creates presumptions under 25-814. The other is not a statute that's instructive as to how to tell people to acknowledge paternity. It's a statute that tells you how to acknowledge paternity so that it is a final form of judgment for paternity. The legislature was clear when they said, as the court has been pointing out, that once filed with the court or with the state, it becomes a determination of paternity and has the same force and effect as a Superior Court judgment.
And the legislature went beyond that to say the only way you get out of that voluntary presumption is to get the court to set it aside based on fraud.
After the 60 days, fraud, duress, or material mistake of fact. I believe that to be true. And within the 6 months prescribed by the rule. And there's an argument made by Mother with respect to that in the Andrew R. dissent, that at any time after the 60 days means that could be at any time, which effectively would do what Mother is trying to do in a sidestepping manner, which allows anybody to come to the court at any time and allege fraud, duress, or material mistake of fact.
For the record, I appreciate you picking up on it and going forward with it. I meant voluntary acknowledgement, not a presumption, because I do not want to confuse the two here.
Thank you.
So, that being said, how do you square our decision in Brumman?
Thank you, Your Honor. So in Brumman, it was clearly, Mother makes the argument in her reply brief. It's a one-sentence addressing of how.
Well, you tell us.
Yeah.
How do you square Brumman?
Well, at paragraph 10 of the Brumman case, it's talking about Andrew R. And in Andrew R., and I quote directly from the Brumman case again at paragraph 10, it says, in that case, we expressly declined to address, quote, whether someone not a party to the proceedings, such as an alleged father who subsequently comes forward, would be constrained in any way by ARS 25-812E when independently challenging a voluntary acknowledgement of paternity. Brumman talks extensively about how a biological father may not even know that the voluntary acknowledgement.
Right, but the statute says what it says.
It
says, I mean, if we're going to enforce the statute in this case, why didn't we enforce it in Brumman?
Well, the statute says under Section E, it says pursuant to Rule 85E or Rule 85C of the Arizona Rules of Family Law Procedure, the mother, father, or child, or a party to the proceeding on a Rule 85 motion. And in Andrew R., or in Brumman, I believe the court was clarifying that because a biological father is not a party to a proceeding, they are not constrained by the time limitations of ARS 25-812 and Rule 85C. In fact, the conclusion to that case specifically says and references biological fathers. It says, based on all the foregoing reasons, we conclude the time limitations of 25-812E and Rule 85C do not apply to a biological father's petition for paternity brought pursuant to 25-803A2.
It's because the biological father could not bring an 85C motion because he wasn't part of the original proceeding.
If they didn't know about it.
Okay.
Sorry.
Oh, you have.
The parties to a VAP clearly know about it. Not only do they know about it, the VAP says things in it that are recited from 25-812, which says that it's going to have the force and effect of a superior court judgment. So Ms. McQuillen and Mr. Hilby signed this voluntary acknowledgement, clearly knowing that this was going to have the same force and effect as a superior court judgment. To allow them then to get out of that, as counsel for mother stated, it's a contract that these parties signed. To allow someone who signed that agreement, who signed that VAP, who signed the document that said it has the same force and effect as a superior court judgment, to come back at any time and say, I'll give you an example here. If let's say that mother and Mr. Hilby never broke up. They're making all kinds of allegations to the trial court, to this court, about how they're no longer together and how she was going to get thrown out on the street despite living with her mother both before and immediately after moving out of Mr. Hilby's residence. What if they're still together? What if they decided, we're going to go to the court and we're going to tell the court that we broke up so that we can get child support from the biological father who doesn't know this kid, who was never introduced to this kid, who was never told about this kid. We're going to get child support so that we have some extra money.
Well, setting aside that parade of possibilities, which isn't on our record or before us, so I don't know why it's relevant. But setting that aside, obviously your client doesn't have any interest in pursuing his fatherly responsibilities or duties and wants to not have any responsibility for this kid, and that's what you're here advocating for. But why should we be punishing the kid? It seems like there was a fraud committed by these two people who signed this acknowledgement of paternity, and why should we allow the kid to suffer and not have his father in his life and his father taking responsibility for him based upon that fraud?
And why should the state, we taxpayers, have to pick up that tab?
Well, a couple of things. If I could very briefly address why that's relevant, because we're setting precedent here to allow somebody in that type of situation, whether mother and Mr. Hilby were actually in that situation where they were, again, committing fraud on the court and telling the court these things. We don't know that.
Yes, and we could also craft a hypothetical where your client has known about the child for the entire time and knew he probably had a child out there and was just relieved that he doesn't have to pay for it. But anyway, move on, please.
Absolutely. But the legislature and the intent that's written into these statutes is why we shouldn't do that. Because the legislature said if you sign this voluntary acknowledgement of paternity, it becomes a final determination of paternity. It is not a presumption. It is a same force and effect as.
And I agree with you, as I said earlier to the other thing. I read 812D as saying that. So now we have a potential fraud on the court. And tell me why this isn't a fraud on the court, that she should be able to set that aside.
Well,
and arguably on behalf of the child.
Well, I'm not sure if it's a fraud on the court. That's a very highly factual thing. But the reason that I believe that mother is coming forward with this fraud on the court argument is because she doesn't really have an argument otherwise. And she wants to maintain some independent action because she wants to pursue Mr. Hufford for child support 4 or 5 years after this child was born. And that's the concern here, is that if we allow this avenue or this avenue for a parent in this situation who signed this document, who said these things in this document, and the legislature that said that this is supposed to be final, if we allow that opening, then anyone can come back at any time and say, if they're together on this and mother says, well, I could get more child support, mother can still get child support from Mr. Hilby.
Well, she still has to prove that your client is the dad and the defendants are the dads. So it's not really a parade of horribles like you're saying. Mm-hmm. But what authority is there? I mean, help me understand a voluntary acknowledgement. Opposing counsel seems to want us to accept the notion that anyone who signs a voluntary acknowledgement knowing that the male is not the true father, that's a fraud. What authorities are there that tell us about other situations in which a voluntary acknowledgement might be really valid?
That a voluntary acknowledgement might be that the argument might be valid?
Well, no, that a voluntary acknowledgement, that a man and a woman can together exercise a voluntary acknowledgement, knowing that the male is not the father. And is there a law for the proposition that that's what a voluntary acknowledgement is all about also?
Doing so even when you know.
Exactly.
I don't have any authority for that. I can say that the voluntary acknowledgement of paternity has language in it which says that you're foregoing your right to a genetic test. So certainly there are going to be people that sign these documents that don't know for sure unless they had a genetic test. I suppose I could say, I'm not even sure that my kids are my kids. I'm pretty certain that they are, but it's not entirely certain without a genetic test.
Well, I'm just wondering, what can we cite that would be contrary to the proposition on the other side, that anytime a male signs a voluntary acknowledgement knowing he's not the father, then that's a fraud? What's contrary to that?
Saying that it isn't a fraud.
I mean, it seems to me there might be a public policy reason to encourage parties to step up, or depending on the relationship and the financial situations, to step up and say, I am going to be that child's father. But is there any law for that proposition?
Well, I suppose one thing that I can think of off the top of my head, I don't have any specific citation, would be Ban v. Quigley with the family unit. The court in Ban v. Quigley was obviously addressing genetic tests and whether a genetic test should even be ordered. You take into consideration the best interest of the child. If there's a voluntary acknowledgement of paternity and that person has stepped up for a period of years, it's in the best interest of the child to continue that family unit. Mm-hmm. So, I would say that it's contrary to public policy to allow this sort of action to take place, whether it's arguing that it's a filed document with the state is, a presumption under 25-814, or if, Mr. Hilby doesn't want to pay child support and mother wants to go after somebody that has more money and can pay more child support, allowing that to occur is contrary to public policy.
But 812E specifically says anytime after the 60-day, you can move to set these voluntary acknowledgements of paternity. So, I mean, the legislature has declared the public policy, which is if there's been a fraud, mistake, or I can't remember what the third thing is. Duress. You can set these aside. So why isn't the proper analysis for the trial court to have analyzed whether there was a fraud on the court and done it that way?
Well, in Andrew R., in the majority opinion, the court talked about this at any time language. The dissent is the portion of the opinion that talks about at any time means at any time. But with other Superior Court judgments, under Rule 85, you have to come to the court within a reasonable period of time, typically 6 months, and certainly the court has spelled out in Andrew R. that it is 6 months. In doing so, the court went through the legislative history and talked about, in 1997, adding Rule 60C to this voluntary acknowledgement, establishment of paternity statute, and said that Rule 60 was plugged into this statute. When they plugged Rule 60 in, they inherently brought in or impliedly brought in all of Rule 60. And if they intended not to bring in all of Rule 60, meaning the time constraints of Rule 60, then they could have said that. They didn't say that. They just brought in Rule 60, now Rule 85, and so you have 6 months from the date that you enter into this voluntary acknowledgement of paternity to allege fraud, duress, or material mistake of fact. You don't have in perpetuity.
They could have said that by saying it at any time.
They said, but
I know it's Andrew R. says what it says, but
yeah, and it makes sense logically that at any time after the 60 days, they didn't say up to the time periods prescribed under Rule 60C, but did they really
have to Rule 85 or Rule 60C? Yes.
Did they really have to say that because they brought the rule in?
The funky part about that is that the Supreme Court can modify 85 or 60 to even shorten that time limit, to make the statutory reference to at any time totally absurd. But I suppose the response would be that the legislature would then modify the statute.
I would say if the legislature wanted to do something about the time limitations, then that's up to the legislature to do it. As it's written
Yeah.
right now, the statute provides for you to bring this sort of action within a reasonable period of time.
Did you have questions of Ms. Doggett?
I would like to hear their position.
Absolutely.
Thank you.
Thank you.
May it please the court. As you know, I'm Joanne Falgett, representing the state in this matter. I would be happy to answer any questions that you might have.
Go ahead.
Why does the state care who pays, it would seem to me the state would have an interest in seeking out someone who has money here, who is the real father.
Right. The state doesn't actually care who ends up paying child support in this case. You're right. The main thing the state is concerned about is that somebody is on the hook for child support to support these children, and we care about enforcement. But in addition to that, the state is interested in ensuring that the statutes are interpreted correctly and as the legislature has written them and according to their plain language.
So your position would be then, according to the plain language, that the voluntary acknowledgement of paternity after the 60-day period became a final judgment, correct?
Correct?
Okay. So how does the state reconcile Drummond with that position?
And if I'm remembering correctly, that's the one in which
Or Drummond.
the biological father came back and was wanting, is that, yeah, and again, when you have somebody who was not a party to the initial lawsuit, whatever it was, that person can look to challenge that lawsuit. But the difference is when you have people who were in fact parties to the voluntary acknowledgement of paternity, which became effective as a court order after it was filed, those parties are the ones bound by Rule 85 and can't come back and challenge that after the time periods have passed. People who were not parties to that action, biological fathers who wish to assert their rights, for example, that weren't involved in the initial action. And one can imagine an actual situation perhaps in which somebody who could have been the biological father might have been involved in an action to establish paternity. But once you have the paternity established, anybody who was a party to establishing that is bound by that court judgment. And certainly the state has an interest, again, in the finality of judgments and in certainty for the children and stability.
And your position would be that the legislature expressed a preference for finality over accuracy in this case?
Certainly, when you have parties who have acknowledged paternity and filed a statement saying, this person is the mother, this person is the father, and they filed it with DES or with the court, and it's become a final judgment, yes, at some point that needs to be final. That child needs to be able to rely on, this is my family unit, and not have that.
The parents should have the right to rely on it as well.
Yes, the parents should have the right to rely on that, and you shouldn't be able to, as a parent, decide, oh, well, I'm not getting along with this person anymore, and in a divorce proceeding, perhaps decide to disown the other parent who has been the child's parent. And again, I hate to go with the parade of horribles concept again, but one can imagine lots of mischief that could result from this if people who were parties to the initial action are allowed at any time to simply voluntarily rescind it.
Well, what makes it difficult here is that we've got the DNA results. Why is the state not interested? Why should the taxpayers have to pay child support effectively in this situation?
And again, because we're not allowing the initial judgment to be undone, the father that signed under the voluntary acknowledgement of paternity in these situations will still be on the hook for child support. So, and again, that goes to he should not be able to come back.
But he's not paying child support, so we are.
True, but he still is. That can be collected at any time down the road. So just because we can't currently find him or collect from him or weren't able to at the time that this was going on, doesn't mean that the state won't catch up with him in the future and garnish his wages or attach his property or do whatever else they do in order to collect child support.
Doesn't the permanency, semi-permanency, quasi-permanency, whatever it is, of the voluntary acknowledgement, doesn't that give the child a stability that the legislature may well have given priority over the issue of who's going to be paying the child support?
Absolutely. The interests of the child are very important. The child has an interest in stability and in knowing that somebody who's been identified as father legally and in a court judgment is going to be father. And again, there may be some exceptions where the biological father, has an interest in challenging that because his rights were not protected in the initial proceedings. But where the biological father isn't in the picture trying to do that, and you're just dealing with the parties that submitted the original VAP, those parties are bound, and that is a final judgment, and they shouldn't be able to simply change their minds and voluntarily rescind a court order. You've got to follow the rules under both Rule 85C or the 85B and C about how to go about challenging a court judgment, and simply the time has passed.
You got 15 more seconds. Anything you want to leave us with?
No, unless there's anything else that you wanted to ask. All right, well, thank you, Your Honors.
Counsel?
All right, there's just a couple of points that I wanted to talk about. First, as Judge Johnson said, we do have a DNA test in this time. So any argument that somebody can't come in and change their mind or not be a parent or such, if there was an objection, father should have objected at the time that he was requested to do a DNA test. He didn't do that. We now have two.
Did you assert waiver below? I mean, it sounds to me like you're making an argument that he's waived any objection to the timeliness now. I'm just wondering, I don't remember seeing that
It's
below.
not so much of a waiver argument. We have the DNA test. There's no way to unring that bell. We have the test. If he didn't want the test to be utilized under 25814C, then he shouldn't have taken the test. And so we have it. It's here. There are two presumptions of paternity. In addition, Judge Johnson, you had spoken to, is there any time when a voluntary acknowledgement of paternity is appropriate if the father is not the biological father? And my answer to that is no. That's why we have adoption statutes. If somebody wants to step up and be a father, then they need to adopt. A voluntary acknowledgement of paternity is not a tool to circumvent the adoption statutes. Arizona.
So that further promotes the notion that any conduct inconsistent with that, according to your theory, is a fraud.
Correct.
Are there cases that talk about the distinction between adoption and voluntary acknowledgement?
We have Alvarado, and in that case, the court specifically says that you can't use a voluntary acknowledgement to circumvent adoption laws.
Okay.
If that was the case, then it would say that in the statute. This can be used instead of adoption. But that's not what it's for. It's to acknowledge paternity. You want to adopt. We have the resources in place to make that happen, but you can't use a voluntary acknowledgement of paternity. It's not an appropriate avenue.
Counsel, you're out of time.
Oh, thank you.
Thank you very much. Folks, we appreciate the argument today. Thank you for the time you spent with us. We're going to take this matter under advisement at this time, and we will issue our decision in due course. Thank you.